us about CERCLA and RCRA today and various other acronyms that they will tell us all about. Jeff is an associate in the environmental practice of Paul Hastings, where he counsels businesses in all aspects of federal, state, and local regulatory compliance, with a focus on air permitting and compliance issues. He also participates in corporate and real estate transactions by conducting environmental due diligence and negotiating contractual language. Michael Lukens is also an associate of Paul Hastings. Both of these gentlemen are located in the Washington, D.C. office. Michael's practice primarily consists of environmental regulatory counseling and environmental due diligence for corporate clients. His representation includes providing legal counsel on environmental issues such as petroleum storage regulations and state agency permitting. And with that, I will turn it over to Mike.
Thank you, and thank you for reminding us to update our firm bios.
They both say you're in your real estate permit.
Yes, at Paul Hastings, there's no environmental umbrella, so we're technically under real estate, although mostly what we do these days is corporate.
We don't actually do any real estate.
Yeah. So if you're buying or selling a house, don't ask us about it afterwards. Thank you for everyone for coming and for dialing in. We have about an hour and a half to an hour and 45 minutes to get through two rather complicated laws. Cool. There's no way we could get through all the intricacies of these two laws in the next hour and a half. Lots of seasoned attorneys are still working through the intricacies. So our goal today is to give you sort of the broad strokes of each. We want you to understand the general goals and mechanisms and the policies behind the laws. Remember that don't take what we say today as hard and fast rules. There's always exceptions upon exceptions. We're giving broad strokes. So always look up your issue if someone asks you to. We're also providing a stack of background materials. Is that?
It's available on the website.
Excellent. So that will provide you more materials and details, and we'll tell you through the presentation when those come into play. As you can see from the screen, we've broken each law into 4 or 5 main topics. We'll touch on each of these as we go through. We're not going to present today just straight recitation of the law and its the subtopics of each. Instead, we're going to take a narrative approach. We're going to tell you a story. And along the way, we'll explain how CERCLA and RCRA are implicated by the actions of the people in our story. To be clear, this is not the greatest story ever told, so feel free to interrupt us as we go with questions.
Pretty good.
It's not the greatest, but it's pretty good. Yeah. But yeah, please interrupt along the way. Before we get to our story, Eli asked us to give you a little background on our practices. As you heard, Jeff and I are both in the environmental group at Paul Hastings in the DC office.
Yeah, I mean, the bios that she just read are a little out of date because I haven't updated the website in a long time. We're going to do as soon as we get back to the office. The broad strokes of our practice are transactional and regulatory compliance. We do a very tiny bit of litigation, but usually that's just sort of consulting on issues that come up in the litigation department, and then they sort of take that knowledge and apply it, and we have nothing else to do with it. We really don't do anything related to kind of the nuts and bolts of environmental litigation. So on the regulatory side, we pretty much do everything that our clients would ask or need of us. So it's anything dealing with contaminated property remediation to just compliance counseling with various clean air, clean water, wastes, hazardous substance management type rules. We do assist clients with permitting. We assist them with environmental reviews under like NEPA and then the Endangered Species Act. We've also done a lot of work with sort of federal programs in the last few years that give out financial assistance to projects. So like the loan guarantee program at DOE was one that we worked on a lot. So that was a big compliance type issue. And then on the transactional side is really kind of where I think the bulk of our practice lies. Probably 60-40, 70-30. Yeah, most of it being on the transactional side. And that's just there's a variety of different sort of business type transactions, from lending to mergers and acquisitions, and really all we're doing in those cases is two things. We're identifying environmental liabilities, so we're doing due diligence on borrowers or sellers of property or businesses to identify what their environmental liability risk exposure is, and then we're managing that liability through deal documents and then post-closing, sort of after the deal, compliance assistance. And that's really the bulk of what our practice involves at Allmon.
So before we dive into our story, we do want to give you a brief 5-10 minute overview of the laws, just so as we go through our story, we're not all lost together. But we'll call this the prologue. So we'll start with CERCLA. Failure that many environmental attorneys have is that we speak in acronyms. So we're talking about the Comprehensive Environmental Response, Compensation, and Liability Act of 1980. At that time, it created the Cleanup Trust Fund, which was the term Superfund. So I'm sure you all hear that, but it's interchangeable, and we use them interchangeably today. CERCLA, CERCLA is the main federal law that seeks to deal with contaminated properties. At its most basic, it's the application of the polluter pays principle. It's exactly what it sounds like. If you pollute, you have to pay to clean up the site. It imposes liability on past and current polluters. You can't just run away from your sites. They will track you down. One of the main goals when they passed CERCLA was to avoid having contaminated property in our country just lie fallow because nobody would redevelop it for fear of contamination. They sought to accomplish this, they mean Congress and EPA, by giving the EPA broad powers to investigate and address contaminated sites. And this is all dirty sites, not just abandoned sites that can be operating. It sets a logical, if harsh, liability scheme to get people to pay for cleanup. And it allows the EPA and private parties to seek to recover their cleanup costs from other polluters. So some stats about Superfund: 44,700 potentially contaminated sites looked at, $20 billion spent by PRPs, so that doesn't include government spending. 1 in 4 Americans lives within a 3 miles of a Superfund site, and if you go to the EPA website, you can punch in your zip code and find out the dirty sites around you. While we're sitting here, there are 7 Superfund sites within inside DC. Just one other note on CERCLA's background and naming. In 1986, Congress amended CERCLA with the Superfund Amendment and Reauthorization Act, often referred to as SARA. We're not going to speak about SARA today because the main important part was EPRA, the Emergency Planning and Community Right to Know Act. It's not really about cleaning up dirty sites. It's about telling first responders and the government what you store on site. So if there's a fire at your property and you have giant tanks of sulfuric acid, the firefighters will know that when they go in. And the community, I guess, at large. But just know that if you hear the term SARA, if someone's talking about a law, they're talking about Superfund or CERCLA. So just another nickname for it. When we speak about CERCLA liability, we're really talking about, quote, releases of a hazardous substance at a facility, defined very broadly in the statute. Assume that any building or piece of land is a facility, because it is. That's how broadly it's defined. Assume that everything that Jeff tells you is hazardous under RCRA is hazardous under CERCLA. And if you spill, dump, abandon something, you have released it. There is one important exception to all this. There's the petroleum exception. Petroleum and petroleum byproducts are not covered by Superfund. That's the main exception to this. We'll talk more about this later, but these are the categories of responsible parties. current owners and operators of a facility, past owners and operators at the time of the disposal of hazardous substances, and arrangers and transporters. And that's exactly what it sounds like, people who arrange or transport hazardous waste to a site. The hammer of Superfund is joint and several liability, and it's strict. Strict meaning without regard to fault or negligence. Joint and several, so a plaintiff can hold one PRP liable for all the cleanup costs at a site, regardless of the percentage of pollution that that one PRP contributed. And it's also retroactive, so actions that occurred prior to the passing of CERCLA are caught up in the liability of CERCLA. We'll talk about defenses later, especially innocent purchasers and lenders. There are acts of God and acts of war and some other ones that are not frequently used. But we will get into all of this when we're telling our story.
RCRA is the flip side of CERCLA. It is the statute that is intended to prevent the occurrence of future Superfund sites and contaminated properties. The idea being that if we manage hazardous waste in accordance with the very strict requirements under RCRA, which stands for the Resource Conservation and Recovery Act. I broke the first rule of this meeting, which is never to use acronyms without introducing what it stands for. RCRA is the Resource Conservation and Recovery Act. And as I was mentioning, it's intended to prevent future Superfund sites. Principally, this is done by protecting groundwater. Groundwater is sort of the focus of what RCRA seeks to preserve, because most of the time when hazardous waste is eventually disposed, it ends up being disposed in some kind of land-based unit. And so there are minimum technology requirements in the statute that are designed to contain hazardous waste so that the constituents of the materials don't leach into the groundwater. Because groundwater is the principal way in which contamination is transported through the environment, how it spreads. That's where you have, contamination at one Superfund site spread through miles and miles because contaminants leach into a groundwater plume and spread. So RCRA has very strict requirements for disposing of anything within the land. It creates a very prescriptive set of practices, and this is what referred to as the cradle-to-grave regulatory regime. It specifies that there are going to be federal involvement from every aspect of the creation of hazardous waste, its transportation, to its ultimate disposal in a RCRA permitted facility. It's a very, it's something that the regulated community complains about constantly because RCRA is a very onerous statute, but it is something that EPA strives to address by making things as easy and efficient as possible.
And it will keep you all employed.
Yes, it'll keep you all employed for a very long time. Both CERCLA and RCRA will do that. The basic structure of our story is reflected in RCRA and CERCLA. RCRA focuses on the before, it focuses on the management of hazardous waste properly. CERCLA is intended to deal with and apportion liability in the event that hazardous waste isn't managed properly. And so that's really going to be reflected in what we talk about. Next slide. The three major programs in RCRA that we're going to be talking about are Subtitle C, D, and I. Subtitle C contains the Hazardous Waste Regulatory Program. All the stuff that I mentioned in the last slide is handled in Subtitle C. It has standards for generators, transporters, and those who operate and own treatment, storage, and disposal facilities. The other two subtitles we're not going to spend as much time on. They are important, but given the limited constraints we have today, we're just not going to dive too deeply into them. Subtitle D focuses on citing, designing, construction standards for solid waste landfills. These are non-hazardous municipal solid waste. And it's chiefly a matter of state law. The federal statute, requires the creation of design standards for these landfills, and then states implement and enforce them. And then the Subtitle I, the Underground Storage Tank Program, is more like Subtitle C insofar as it's a command and control type of statute. statute, but it's not focused on hazardous waste necessarily. It focuses on any kind of container that's underground. So anywhere you see gas station, you see an underground storage tank, and that's what Subtitle I focuses on. Just a note about federal preemption and delegation. Subtitles C and I are principally under EPA's authority to implement and enforce, but states have the ability to apply to EPA to get the authority to implement the program themselves, with EPA acting as a backstop in case anything goes wrong. And by and large, subtitles C and I for the vast majority of states have been delegated to states to implement. That also means that subtitles C and I represent kind of the floor of regulation, where states can't go beneath that in what they implement, but they can go far beyond and implement rules that are more strict than what RCRA requires. And California is a good example of that. As a matter of practice, if you ever have anything that deals with California, always refer to the state rules, because they will certainly will be different and will definitely be more strict.
And confusingly put together.
Yeah, confusingly put together, because they like split regulation between state agencies and county regulations, and it's
Apologies to anybody from California.
it's a mess.
It's all their fault. So, our story in 3 parts. So these are the people in our story. Walter, who owns a boutique chemical company in New Mexico, White Pharmaceuticals. Our second character is Jesse, who also lives in New Mexico and owns and operates a company that hauls hazardous waste, Pinkman Waste Hauling. And Gus, a simple farmer, owns a farm outside of Santa Fe, close to Pueblos Hermanos farms. So we will be following the stories of these 3 gentlemen. And as with all great stories, it starts with a 55-gallon barrel. In the commercial and industrial sectors, this is how people store generally virgin and used materials. And as you practice, you will run into these a lot. It would be hard to
Not actually like.
don't run into them and tip them over, because that's gonna be a problem. If you go into a manufacturing facility, you're gonna find a 55-gallon barrel. So our main character at this point, Walter, has a barrel in his boutique pharmaceutical shop.
Yeah, so the first question Walter has to know is, he has this material that's a byproduct from his pharmaceutical manufacturing process, and he's not really sure what to do with it. He knows he needs to get rid of it, and that he can't just bury it in the ground. So we need to help, or Walter needs to figure out what to do. He's not sure whether or not this drum is subject to Subtitle C of RCRA, and so to determine that, we look at whether or not the material is actually considered solid waste, because under Subtitle C, the concept of whether or not a material is a solid waste is considered the gatekeeper concept to the whole statute. Unless you have a solid waste, you can't then move on to have hazardous waste that's subject to Subtitle C. So, all the generators, and including Walter, they're going to have obligations that include registration requirements, manifesting and documentation requirements for where they can store this material and what they can store it in. He's going to have to keep records of the material and how much of it he generates and where he keeps it. He's going to have to train all his employees, and he's going to have to do accident and release prevention training for everyone. And the idea being is that none of this stuff comes into play unless what he has is solid waste. So it's an incredibly important concept, but unfortunately for practitioners, it's also one of the most convoluted and complicated ideas in the whole statute. The idea starts in the statutory definition of what is considered solid waste, and that has traditionally hinged on the definition of the term discard. In general, discarding means abandoning through disposal or burning, or any storage, accumulation, or treatment to disposal prior to burning. So it's simple enough. It basically just means abandoning the material. But the idea actually gets more complicated. Good job. When you get into the area of industrial recycling, because certain types of industrial recycling are going to be exempt from regulation under Subtitle C, because the material won't necessarily be considered solid waste. And EPA has built in some exceptions to the definition of what is and what is not discarded, kind of as a way to promote recycling. The complexity arises from two competing policy goals. On the one hand, EPA really wants to encourage recycling. It wants to, reduce the amount of waste materials that are going to be subject to management in TSDF and sort of treatment, storage, and disposal facilities. But they also want to make sure that the efficient reuse of these materials is done in an environmentally sound manner, because you can't just take the material and sort of claim to be recycling it when you're really just burning it in your boilers in order to get rid of it, because that creates a lot of extremely hazardous byproducts. So EPA wants to say that things like that, reuse in that form is considered more like solid waste, but reuse in more environmentally sound forms is going to be considered not subject to Subtitle C, not considered solid waste. And the determination of what that is, EPA has two concepts. One is called use or reuse, which is not considered solid waste, and the other is reclamation. And when you reclaim something, it's considered to be, the material is considered to be solid waste. Use or reuse generally just means what the terms specify. Using the secondary material, the material that's the byproduct of your process within another industrial process. It's basically taking the stuff that comes out of the end of the pipe and sticking it back in your manufacturing process or another process, just as it comes out. You're not treating it, you're not doing anything to it by and large. There are some exceptions to this. The exceptions deal with land application. It deals with when you burn things. You can't burn something for energy recovery and just call it recycling. Dioxin materials are exempt from this, and then speculative accumulation is exempt from allowable recycling. Speculative accumulation is just leaving things in drums or in a pile and saying, yeah, we're going to get to it and we're going to reuse it someday. That's something that the industry loves to try to claim to do, because eventually they'll come up with a use for it someday, we hope. But EPA says, no, you can't actually do that. You have to, store it on site for an appropriate amount of time and get rid of it. The other category that EPA has come up with is reclamation. Reclamation means extracting a valuable component from the secondary material. It's things like taking spent solvent and extracting the useful components of it and getting rid of the rest. Those types of processes, EPA considers more like, sort of dealing with treating hazardous and solid waste. So in those situations, EPA is going to consider that to be subject to regulation under Subtitle C. Now, in the last 5 years, this has been subject to considerable fluctuation under the regulations. In 2008, the end of the Bush administration, final rules were promulgated that were more industry friendly. Ostensibly, what they did is they took categories of reclamation and they said that these certain processes are not going to be subject to strict Subtitle C regulation. The three big sort of fallouts from the 2008 rules are that materials that are reclaimed subject to the generator's exclusive control. There are certain processes there that aren't going to be subject to Subtitle C. Hazardous secondary materials that are transferred off-site to a recycling company. EPA said that in certain circumstances that's not going to be subject to Subtitle C. And then, as sort of an overarching concept, they codified criteria for what they consider sham recycling. And that's just a way for the agency to look at all these processes in the context of their enforcement to determine whether or not what's going on is legitimate recycling or not. And remember, the important upshot of all of this is that to the extent that more reclamation processes are considered solid waste, that means more processes are subject to Subtitle C. So to the extent that they're cut out of that, that's a big help to industry that wants to avoid Subtitle C regulation. Fast forward to 2011, the EPA proposed rules, these haven't yet been finalized, but they're percolating through the agency, that, among other things, roll back many of the 2008 allowances for reclamation. So it's this give and pull between allowing more things to be done, more reclaimed processes to occur outside of Subtitle C, and then pulling back and saying that certain reclamation processes are going to be subject to further regulation under Subtitle C. The obvious thing here is that in this circumstance, the most of your cases are going to cut along this line. You know, the specific issues dealing with reclamation that have come down in the last few years that are subject to a lot of regulatory investigation and consideration right now, by and large aren't going to come up in 99% of these cases. Most of the time, if you're dealing with industrial recycling, it's going to fall on one side of this line or another. You see on the slide. But in Walter's case, as we return to the barrel that he's got, his situation's easy. He's clearly discarding this barrel. He doesn't want to do anything with it. He's not trying to take the barrel and put it back into its process, and he's not trying to extract some kind of valuable component of it by treating it in some way. So next slide. So he knows his material is solid waste, but the question becomes, is it hazardous?
We practiced that yesterday. So Walter knows that his barrel is hazardous. The question, or is solid waste. The question is it hazardous? Under its
Spoiler,
it is. Our story would end right now. We'd all go home. Under its RCRA authority, EPA has developed two methods for determining if a solid waste is a hazardous waste. First, the EPA can list a waste as hazardous. It has to go through notice and comment rulemaking. This is the very complicated way. It's lengthy, and thus not the way EPA likes to go. There are 800 listed hazardous wastes, and you can look them up in the CFR if you're interested. There's generally four types. There's F-list wastes, which are waste from 7 non-industry specific sources. And they include things like spent solvents and wastewater treatment sludge. Waste F001, the first one on that list, is TCE, which is a solvent. It's used in metal factories as a degreaser. And you'll often run into it, or one of its brethren. The second type is K-list wastes. These are hazardous wastes identified from specific industrial sources: petroleum refining, wood preservation, iron and steel making are 3 of the industries whose wastes are listed on the K-list. And P and U lists are discarded commercial chemical products. It's important to note for P and U lists that it's only if it's in its pure form or if it's the sole active ingredient. Just having a P and U list chemical in a sunscreen, for example, wouldn't get it into the hazardous waste world. The more common way that waste is designated as hazardous is if it exhibits one of 4 characteristics shown by those symbols up there. Ignitability, which is the tendency of the waste to catch fire. Corrosiveness, a measure of pH, is it too basic or too acidic? Reactivity, which is the tendency of the waste to explode and to release toxic gases. And toxicity, which is a measure of the waste to leach toxins into the environment. If you're a generator like Walter, you have an obligation to determine if your solid waste is hazardous. You can either do testing, or you can have what's your knowledge of the waste. Most people go with the knowledge, because most people know if their waste is hazardous. If you have a barrel of spent sulfuric acid, you don't need to test it, you know that it's hazardous. But you do need to keep records of the determination that you make. There are a few other rules that you should be aware of. There's the mixture rule. So if you have a solid waste and you mix it with a listed waste, it's a hazardous waste. Regardless of how much listed waste is in there, it's hazardous. But if you mix a solid waste and a characteristic waste, it's only hazardous if the whole mixture itself is, say, ignitable or acidic to the point of passing a threshold. There's the contained in rule, which is environmental media, which is, you can think of it like soil. If that contains a hazardous waste and you dig it up and dispose of it, it has to be disposed of as a hazardous waste. That'll be important when we get around to cleaning up properties at the towards the back end of our story. And there's the derived from rule. So if you're treating a hazardous waste at a TSDF facility, whatever comes out of that treatment is considered hazardous itself. So Walter goes through the whole process. He does a determination, realizes it is hazardous, what he has in his barrel. And now he has to figure out what he does with it. So he calls Jesse and Pinkman Hauling and says, hey, come get my barrel of hazardous waste off my site. And Jesse tells Walter that he will be by in 45 days because he's super busy these days. So the question is, what can Walter do, or what should Walter do during the 45 days that he has his barrel on site?
And also the question is, can he actually keep his barrel on site for 45 days? Because one of the important requirements under RCRA is that you don't speculatively accumulate this stuff. You actually have to get it off site within a specified period of time. And Walter is unsure if that 45 days is going to run afoul of the RCRA regulations. The rules for the storage periods of time for generators all depend on how much hazardous waste as a total quantity, not just among individual waste types, but among all the hazardous waste. How much are you generating in a given month? There are three types of classifications. There's large quantity generators, small quantity generators, and conditionally exempt small quantity generators. The requirements for each are progressively more strict the more waste you generate. Starting with the large quantity generators, these are people who generate 1,000 or more kilograms per month in any calendar. 1,000 kilograms or more of hazardous waste in any calendar month. These guys are subject to the most stringent forms of regulation, and they're your Chevrons, your chemical facilities, your refineries in the world that are typically large quantity generators. One of the things that they have to do that other types of generators don't have to do is they have to fill out biennial reports. Biennial reports is a 2-year span of your hazardous waste generation and management activity. You're also subject to waste reduction requirements as well. Small quantity generators are the next rung in the ladder. They're storing on-site, they're generating on-site, more than 100 kilograms, but less than 1,000 kilograms in any calendar month. They can store things on-site for between 180 and 270 days. The 270 day is sort of the outside limit and depends on how far you're going to be shipping your hazardous waste off-site. If you ship it more than a distance of greater than 200 miles, you can store it for 270 days. This final category is the conditionally exempt small quantity generators. These are these entities are kind of like laboratories. They're storing small lab pack quantities of waste. They can store things on site indefinitely, and they're generating 100 kilograms or less per month of hazardous waste. Their only requirement is really that they store no more than 1,000 kilograms on site at any given time, and that they send their waste to a permitted facility. They don't have to manifest. They don't have to do a lot. But so in either of these cases, Walter with his 45 days isn't going to be running afoul of storage regulations. He can permissibly, regardless of which classification he fits into, store his waste on site for 45 days. One of the important things about this that's good to mention is that this is one of the most common and most sort of treacherous violations among hazardous waste generators. The reason for that is that if you are a generator and you exceed the permissible on-site storage time, you become subject automatically to all the requirements that treatment, storage, and disposal facilities are subject to. So in addition to violating your generator requirements, if you exceed the on-site storage timeframes, you are automatically in violation of all the TSDF regulations that would apply to a hazardous waste storage facility. So it's something that EPA uses to encourage people get their hazardous waste managed and get it moved off-site in an efficient way. Again, to sort of prevent speculative accumulation and just things gathering up at individual facilities. Next slide.
So Walter knows that he can keep his barrel for 45 days. What must he do with his barrel? To begin with, he must get an EPA ID number. All hazardous waste generators must register with the EPA and or the state, depending on which state they're in. EPA ID number is tagged to a specific company, so the EPA or the state can track down shipments of waste. And with respect to the actual barrel, the rules for storing are common sense. You have to have a container that is suitable for what you're storing it in. You can't store acid in a bathtub on the second floor of a house, or it will eat through and make a mess.
Hilarity ensues.
And hilarity ensues. The container must be labeled. This is a typical label that you see on the screen. You have to keep your containers closed. You can't leave them outside uncovered and let the rain just slowly wash away your hazardous waste. That's a problem. And you have to handle the containers and store them so as to not rupture them. So you can't let your forklift operators drive too close, or they will drive over them, create a spill. Policy here is fairly obvious. We want to keep the waste inside the containers and not in the environment. And you don't want spills, and that brings us to he as a generator, Walter, needs to have a contingency plan in place that lays out what to do in the case of a spill, lay out the emergency procedures. If there is a spill, he has to notify the regulators right away, the EPA, or the state and local folks. In some cases, the fire department, depending on what you're storing. And as the storage specs change, you have to update your plan. You can't just write one in 1986 and just leave it in a file somewhere and hope it's fine.
So part of this is, where he can store his materials and what he can store them in. As Michael mentioned, one of the important things is materials compatibility with your stored waste. So that's why you're going to see, typically two types of mechanisms for storing them. You've got your 55-gallon barrels, and then you've got tanks. You also have a variety of smaller containers that labs use, but in general, in industrial operations, you have barrels and you have tanks. And the rules for where and how you can store these things are, as Michael mentioned, they're fairly common sense, and they're intended to assure containment of the material and prevent releases into the environment. For containers, the requirements for storage is that you have a centralized storage area for them, that your containers of hazardous waste cannot be scattered about your facility. The reason for this is that the EPA wants to make sure that generators all keep their materials together in one place so that it can be tracked and shipped off-site efficiently and not lost. The satellite accumulation rule is the only exception to this, and it basically permits generators to store up to 55-gallon drums of waste material at the point of its generation. So if you think of your industrial process has a pipe at the end of it that's producing waste, you can leave a barrel at the end of the pipe and collect that material up to 55 gallons. And then once you get 55 gallons, you seal the barrel, you move it over to your centralized storage area, and you replace it with a new one. The rule for tanks is, again, relatively straightforward. The devices must be made of non-earthen materials, so you're not storing these in a pit in the ground. Again, it's relatively common sense, but during the 1970s and before, it was not at all common sense. The fundamental safety rule for storage of hazardous waste in tanks is the idea of secondary containment, and this is part of the reason why RCRA is a useful statute to learn, is because it has a lot of these concepts, release prevention, containment, all this stuff. You see these ideas expressed throughout environmental laws that deal with hazardous substance control. And so one of the important ones is secondary containment. And for tanks, basically that means having redundancies in your containers so that if there's a breach within one, that there's an exterior barrier that's going to contain the material that's released as a result of that breach. So you see double-walled tanks is one mechanism for secondary containment. Another is containment diking, which is basically just a concrete barrier around a tank, so that if there is release of the material out of the tank, all it does is spill into the concrete barrier, and then you can easily clean it up. It's not going to flow into the environment. And the important rule for secondary containment, by and large, especially for containment diking, is that you have to have enough containment so that all the material in the tank is released. It'll all get contained within the secondary containment. And again, it's relatively straightforward, and you see the concept expressed throughout environmental laws dealing with hazardous substance control.
So Walter also must maintain records. Records like that. Yeah. For all of the smallest generators, the type of records that must be kept on site include old manifests, waste determinations, how you realize or how you figured out your solid waste is hazardous, exception reports, which we'll discuss when we look at manifests. This is maybe not the worst penalty, but it is often a penalty that people get because they don't keep records on site, and it's an easy penalty to avoid. The law requires 3 years of record keeping. We advise our clients to keep them forever to avoid inspection issues, but also when we get to the Superfund section of the story, we'll talk about how the EPA uses manifests to figure out who's a PRP, and we want to know, or our client will want to know, if they can refute that, or if they have manifests that show that they sent the waste to the wrong place.
I think it's easier and easier because the agency's moving towards electronic manifesting, so it's not really a big deal.
It'll be on the interwebs. Yeah. And as Jeff mentioned, for large quantity generators, biannual reports, every 2 years you have to tell the EPA and generally the state regulatory agency the types and quantities of hazardous waste that you have generated and sent off-site, how you sent them off-site, who you used, and where those wastes ended up. So while waiting for his 45 days of the barrel to end, Walter takes a walk through his factory and trips over a pile of batteries, and he almost falls into a box of spent light bulbs. What Walter has tripped over is a unique type of hazardous waste termed universal waste. It includes things like batteries, certain types of pesticides, mercury-containing equipment, and bulbs. I'm sure everyone here has universal waste in their condo or house or BlackBerry. But it's not an exception to what is hazardous waste. It's just a sort of like a subset, and it's treated differently. They each have a small amount of hazardous substance inside, and they are everywhere. So the goal when giving them less stringent rules is to reduce the quantity of these wastes going to your local landfill. I'm sure some of you have thrown a battery into the trash instead of recycling it.
Don't do that.
Yeah, don't. Just take it to your local recycling center. This has been a public service announcement. It encourages recycling, and we want to, hazardous waste industry, it's expensive. We want to avoid using valuable resources in that industry for less risky wastes. So generally, generators of universal waste can store them for longer periods of time. They don't need to count universal waste in their hazardous waste reporting. They're not storing them in, expensive steel drums. You wouldn't store acid in a cardboard box, but you can store spent light bulbs in one. For example, a small quantity generator of hazardous waste can, as Jeff discussed, keep waste on site for 180 or 270 days. You must have an EPA ID number and has to use manifest when shipping. A small quantity generator of universal waste can keep the universal waste on site for up to a year. Does not need an ID number, and there's no manifest needed when they ship these out. You do need to send them to a permitted universal waste treatment or recycling facility. But if these types of wastes, which all of your clients will have on site, are just treated a little less stringently. So while recovering from his fall, which he is waiting, and Jesse shows up to take his barrel away. So the question is, Walter as the generator, what does he have to do when Jesse shows up? Do his obligations just end? He can walk away and assume that the barrel ends up where it should? No. Absolutely not.
Of course not.
First, he has to make sure that whoever's hauling his waste is a permitted, qualified, certified hauler. If Jesse shows up with a kayak, he can't just turn up on a guy. And this also leads us to the issue of the manifest. What you see on the screen is the EPA's Uniform Hazardous Waste Manifest. This is sort of the standard, but some states use their own forms. Texas, California, some of those states. But this is, regardless of what it looks like, this is the backbone of the cradle to grave waste tracking system. At each turn, when something happens to Walter's waste, a manifest will come into play. He'll fill it out, the hauler will fill it out, eventually it'll get to a treatment facility and they will fill it out. So at each turn, this manifest is getting written on and a copy is being produced. So at the end of the day, the generator, the transporter, and the final disposal facility all have a piece of paper that tracks where the waste came from and where it ended up. And some states also require that you send them a copy so that just in case they need to figure it out, they'll have a copy. And it is going slowly online. The real important, or not the real important, the other important part of this process is that when the waste gets to the final place that it's going, the treatment facility, that treatment facility needs to send Walter back a copy so he knows where his waste ended up. If he doesn't get a copy back, he has an obligation to fill out and submit an exception report. This is telling the EPA or your state agency that he'd be saying, I sent waste off-site, I didn't get a report back, I don't know where my barrel ended up, you should probably look into this. It's possible that my barrel ended up on a farm somewhere, perchance.
Maybe.
Maybe, I don't know. And the EPA will investigate when they get exception reports. As we mentioned earlier, these also form the backbone of EPA investigations. They will look at manifests to know who sent waste to a contaminated property, so they know who to go after for cleanup costs or to order cleanup.
There have been a number of times in our practices where we've been presented with a box of manifests. And we've gone through and EPA has said, hey, we think your client may have sent such and such waste to this facility, and we look at manifests in order to determine whether or not they have any connection to it. And we go through them and we figure out one way or the other. A lot of times, it ends up they didn't and they had the company wrong, and we write a letter to EPA and we say, hey, based on the manifest, nothing went there. So it's a tool that everybody uses in this area of practice to sort of figure things out on the RCRA and the CERCLA side. So as this that concludes part one of our story. Now we get into part two, titled "The Dream Turns into the Nightmare." As Walter watches Jesse take his barrel away, he daydreams about his barrel's new home. And this involves the barrel's ultimate resting place. What I'm about ready to talk about is what we have sort of termed TSDFs throughout the course of the presentation. And TSDFs is the agency acronym for Treatment, Storage, and Disposal Facility. This represents the grave component of the Cradle to Grave regulatory program. And EPA has come up with very, very stringent regulations governing all aspects of this process. The backbone of the process is the permit program. There are permit and then there are interim status facilities. You don't really see interim status facilities anymore. Interim status facilities were basically a way for EPA to transition existing facilities at the time of the statute's creation and when EPA came up with their TSDF permitting rules. And the rules for interim status basically said, you're existing at this time, you need to come into compliance, and you need to get yourself a permit as soon as possible. In reality, it took a very, very long time. Facilities remain interim status for, over a decade, in some cases more. But it was a way for EPA to impose requirements that are like the TSDF permit onto TSDFs that hadn't gotten the permit secured just yet. Permitting is a very long process, and so it involved challenges to EPA designations of facilities, and so that really kind of explains the length of time. But the statute accounted for that as being permitted and interim status. The way that the program is organized for an individual permitted facility is they take the various.
Sure. What button works the one at the middle star? There. Cool.
Nice. So these various things on here are all. Honestly, if you're listening to this on the phone, you can't see what I'm pointing at, but sorry. I'm pointing at the various things on the slide that are the different treatment programs. These are all waste management units, and the permit in its substantive form revolves around conditions and treatment standards that are applied to these various treatment, storage, and disposal units. You have a guy treating materials here, another guy treating stuff, and then this is construction of a landfill or a surface impoundment where waste materials will eventually end up. You have a drum storage area here. These are all. This is what the program focused around. The basic standard that governs all this is that the assurance of containment of hazardous waste for so long as the material maintains its hazardous characteristics. So whatever mechanisms you're putting in place, they have to assure that as long as you're holding it, it's going to maintain. As long as you're holding it, the hazardous characteristics have to be known. As long as the hazardous characteristics are there, your containment has to hold. Sorry about that. The two concepts that govern this are called land treatment restrictions and then minimum technology requirements. The minimum technology requirements are the standards that apply to the unit once it's deposited into the ground, and the land disposal restrictions are the treatment standards that govern the waste before it goes into the ground. So these are complementary concepts, and the idea is that before something is put into a surface impoundment, as you see on the right-hand side, it has to undergo a certain amount of treatment to reduce its hazardous characteristics, such that treatment within the allowing it to remain within the land unit will be effective, and over the course of the land containment unit's use, the material will degrade over time. It's just a way to assure that constituents aren't released into the environment. The rules for the minimum technology requirements applicable to land disposal units, like the one you see on the slide. Again, this is another one of those concepts like secondary containment that are expressed sort of throughout environmental laws dealing with waste management. You see standards like the ones I'm about ready to talk about expressed in Subtitle D for solid waste management. And the three big components of that you see on the screen here are expressed and required for any kind of land disposal unit. And this is as you can see, it's a very wavy, very large.
It's the largest hazardous waste impoundment.
Yeah, it's got a lot of waves. It's Lake Erie. They turned it into a surface impoundment in the 1980s. So.
Don't go swimming.
Don't go swimming. So the first thing you have is you have double liners, okay? And this is saying you've got some, synthetic material typically here that keeps the material in place, and then, like with secondary containment, you've got an extra layer of protection. This is like a bentonite or some kind of clay composite material that, it has a second line of protection. And then inevitably, a system for anything that, when you say leach, we basically mean seeping through. And anything that seeps through is going to get collected by the leachate collection system. And then the sort of final line of defense for land containment units is groundwater monitoring wells. This is basically an alert detection system that says if something ever actually does make it through the liners and the leachate detection system, we're going to be monitoring the soil and groundwater in the area around, usually in the down gradient or in the sort of downflow direction, to identify, collect, and then ultimately deal with, implement remediation if this ever takes place. The second big component of, the second big component of the TSDF regulation is the area of closure and financial assurance. These are requirements that are intended to assure the long-term security of containment mechanisms, so that once a facility closes, if it goes bankrupt, or if they're just, they've maxed out their permitted containment area, that mechanisms are put in place to assure that, while it's closed, nothing bad happens. And so what TSDFs are required to do is they're required, on one hand, to implement a plan that assures that all aspects of care are planned for and accounted for. And closure plans have to be continually updated as facilities are modified, as circumstances change. They have to be part of their permit, effectively. And if there's any long-term supervision after the facility closes, what's often termed as post-closure care, that long-term supervision and management has to be written into plan as well. And then the other big component is financial assurance. Financial assurance acts, as it says, as sort of an insurance mechanism to make sure that if the closure plan is ever put into place, that there is going to be money available that the TSDF operator has put up to make sure that this can all be implemented. And it has to be set apart from the company's books and records. So it has to be like a surety bond. It has to be a letter of credit. It has to be a corporate guarantee. It has to be something that isn't part of the operating budget of the facility, so that when the facility closes or if it goes bankrupt, this insurance mechanism will be there to provide funding for closure. And that's another big important part of the closure plan, is you have to have a cost estimate. So the cost estimate for closure in your plan has an accompanying and corresponding financial assurance mechanism that will fund the implementation of the closure plan if anything ever goes wrong. So that is sort of the way in which containment is assured for as long as the hazardous wastes maintain their hazardous characteristics.
So in addition to the types of TSDF units that Jeff just talked about, sort of the customary types, there are other types that RCRA looks at. Most importantly is the underground injection well. A cartoon of one is on the screen. It's exactly what it sounds like. You drill a well deep into the ground and you jam hazardous waste down into it. They are often used in
More common than you'd like to think.
roughly half of the 42 million tons of hazardous waste generated in 2005 was deep well injected as a way of disposal. UICs are regulated under RCRA, but they're chiefly regulated under the Safe Drinking Water Act for obvious reasons. This is maybe sitting next to an aquifer. We won't go into too much detail, but just know that generally your UIC you have to prove that it will contain the waste for as long as the waste is hazardous. So if whatever's in there will be hazardous for 1,000 years, you have to prove that your UIC will still be stable for 1,000 years. There's also specific rules for other types of TSDF facilities, like incinerators and facilities that burn waste to generate energy. We're also not going to go into that today. It's way too far into the weeds. But just know that for those types, there are specific rules. There's also specific rules under the Clean Air Act for air emissions coming off of these types of facilities. There's a lot of emissions that are generated while treating hazardous waste, a lot of volatiles.
As stuff is maintained in a surface impoundment, it gives off volatiles. And in the same thing, you have like vents and control mechanisms for treatment, because it gives off fumes that are really, really nasty. So Walter is also comforted in his daydream. He dreams about the fact that that RCRA has both a comprehensive corrective action provision and a strict enforcement regime. The corrective action program is kind of the mirror image of the Superfund cleanup program. It is really only applicable to TSDFs. It is the cleanup program that is intended to make sure that TSDFs continue operating even when they've had a release. So when we showed you the diagram earlier about the groundwater monitoring system, if they've got a detection and it's a release that they need to clean up, that information will be known to EPA because of their information gathering abilities, and then corrective action will then be built in to the operating parameters for that facility's permit, and so they'll be implementing remediation under the corrective action program at the same time as they're continuing to operate and accepting waste. It's imposed on a number of different mechanisms. There is corrective action orders for interim status facilities that EPA will just issue to those operating under interim status. And then, as I mentioned, permit conditions can also be set up for operating TSDFs. The final mechanism that EPA has at its disposal for requiring corrective action is under Section 7003 of the Act. This is sort of the broad backstop authority EPA has to deal with what the statute terms imminent and substantial endangerment. So anytime EPA identifies imminent and substantial endangerment, dealing with the management of solid waste, not just hazardous waste, but anytime the management of solid waste creates an imminent and substantial endangerment, EPA has the authority to issue orders to compel correction of that. So it doesn't just deal with TSDFs, it deals with the entire waste management problem as a whole. The process is very much in the weeds. Just know that it mirrors the Superfund program, and that there are specific corrective action mechanisms that are put into place for operating TSDFs to assure that they can continue operating. We mentioned waste management units. Well, for corrective action program, they have corrective action management units, and those become units where remediation wastes are dealt with as a result of a release from a TSDF facility. On the enforcement side of things, EPA has incredibly broad powers when it comes to TSDFs. One thing I mentioned was the information gathering power. EPA has the ability to access any kind of information the agency wants. So in addition to like regular reports that the agency receives from operating TSDFs, if the agency believes that there is a substantial hazard arising from a TSDF facility, it can order the TSDF to implement its own independent soil and groundwater investigation and report those results to EPA. And then EPA will use that information to determine whether or not it wants to issue corrective action orders. EPA also has enforcement powers to order people to come into compliance, to correct issues, to assess civil penalties, and even suspend permits for violations. Furthermore, if none of this works to compel compliance, EPA will refer the issue to DOJ, and DOJ will bring civil action to compel compliance at the agency. The last thing to note on enforcement powers is that RCRA includes citizen enforcement powers that are kind of the flip side to the agency's ability under imminent substantial endangerment, and then also the agency's enforcement powers. So citizens have the ability to both bring citizen suits to order compliance with any permit, regulation, or EPA order. They also have the ability, the same as EPA, to go to federal court and request an injunction to abate an imminent and substantial endangerment, dealing again with solid waste, not just hazardous waste. So this is this is a big power that citizens and the EPA have. It's been largely eclipsed by CERCLA because CERCLA has the ability to recoup money, and under RCRA you can't do that. The only thing you can do under RCRA is just compel a cleanup. But the authority is quite broad because it deals with solid waste and not just hazardous waste. So
Jesse has the barrel, getting back to Jesse, and he is driving around and he realizes how expensive it is to take hazardous waste to TSDF, so he decides to try and save some cash. And his first idea is he tries to take the barrel to a landfill, a sanitary landfill. This is you'll hear people say MSW, Municipal Solid Waste Landfill, Sanitary Landfill. It's where your trash from your house ends up. It's a solid waste landfill. This is RCRA Subtitle D, sets the standards, but these are generally regulated at the state level. Regulations include rules for citing. You can't put a landfill in the middle of a residential neighborhood. You can't put it too close to an airport because birds fly off landfills and get in the way of planes. They include rules on how to build a solid waste landfill. You'll see on the picture that it's much like the TSDF unit that Jeff described. We have leachate collection, we have miners, we have groundwater monitoring wells, all for the same reason. As your waste decomposes, it creates leachate, a liquid that you don't want getting out and getting into groundwater. That's something you may want to drink someday. And also, like TSDFs, you can't just fill a landfill up and walk away. There has to be a closure plan in place. You have to have some sort of financial mechanism to pay for that closure. Generally, when they close them, they cover them with soil and revegetate, so you get these kind of strange geometric-looking parks.
If you've ever driven to Virginia Beach, you see Mount Trashmore as a park. It's a park, and it's a landfill that they vegetated over, and they will park next to it.
Yep. So if you see something that looks like that, it may be an old solid waste landfill. That is now a park.
Yep.
So I haven't been turned away at the landfill because they knew what they were doing and they saw a barrel of hazardous waste and they're like, no, you're not putting that here. Jesse drives around and continues to figure out what to do, and he needs to stop for gas for his truck, which brings us to underground storage tanks, subtitle I of RCRA. It's another area where RCRA sets the federal standards, but it's left to the states or local agencies to regulate. UST's underground storage tanks are everywhere. Every time you pass a gas station, a UPS facility, some farms, a manufacturing facility, chances are there's an underground storage tank. Conservative estimates put the number of active tanks in the United States at 700,000, and that's a lot of tanks storing petroleum under the ground. Because if you leave a tank, eventually it will leak into the ground and cause contamination. So RCRA sets standards to avoid that contamination. You need to have leak detection. The picture on the bottom right shows a guy sticking a stick into a tank, which for a long time was how people did leak detection, but now we do electronic, smell it, sniff it. Electronic leak detection, if your tank starts to leak, it sets off an alarm. It's the standard practice. You need to have spill and overfill protection for when people fill up their car, they don't just, spill gas everywhere. If you drive away with the hose still attached to your car, there's a shutoff valve, so it won't spill gas everywhere.
So don't worry about that.
Yeah.
You should worry about that.
Drive away.
Drive away.
And cathodic protection for steel tanks, they're not really used much anymore. It's usually either steel wrapped in fiberglass or double fiberglass. Generally double walled tanks are used. And as a recurring theme, you can't just walk away from a tank when you're done using it. You have to either pull it out of the ground and see if it's leaked, or you have to empty it and fill it with an inert material like sand or concrete. If you see abandoned gas stations that nobody wants to buy, it's probably because there was a tank that leaked and it needs to be looked up. It's a small part of RCRA, and when you look at the law as a whole, but it's ubiquitous because of the number of tanks that are around.
So all gassed up with nowhere to go, Jesse is at a loss because he doesn't want to have to pay to have this treated at a TSDF facility. He wants to make a little extra money and just offload this tank somewhere. So he remembers he has this friend who has a big farm with lots of empty, abandoned fallow space. And so the farmer happily lets Jesse drop the barrels off in the back And then a few months later, the farmer decides he's going to sell his property to Gus. And Gus is going to put in chicken farms and expand his operation. But Gus doesn't go into this back area because it's a bunch of fallow land, so nobody knows it's back there.
And this may sound crazy, but this happens. We just did a matter for our client where the guy was just, burying drums in the backyard, basically.
Yeah, I mean, it does happen. I mean, there are transporter operators, less so now with RCRA, but you do still see like the fallout of people who said, yeah, I'll take your waste and I'll manage it, and they'll basically pay the rate for proper management, and then they'll collect the delta from burying it somewhere. So it still happens, and it creates a mess. So 2 years go by, and Gus is, he's enjoying the profits of his booming chicken farm. So he goes for a walk to check out the nature in the back 40, and he finds Walter's drum, and it's abandoned and it's empty because, as we mentioned before, containment in steel barrels, or really in anything, never lasts forever. It will eventually leak, and the materials will all seep out. And there's Walter's drum, abandoned and empty, and it's gathered friends, because over the years, a number of other people have come on the property, including Jesse, and they've dropped off drums for disposal. So, what we have is a waste management gone wrong, and now we have a Superfund site on our hands.
So after Gus finds the barrels, he's not knowing what to do, he calls the EPA, which is the right thing to do. If you're ever in your backyard and find a bunch of barrels.
It's also required. It's also
It is required.
It's not just nice,
So the EPA begins an investigation into the issue. And an EPA investigation can include both on-site investigation and collecting information from suspected PRPs. CERCLA Section 104, now that we're in the CERCLA universe, grants the EPA broad powers to investigate releases or suspected releases, like at Gus's farm. And the standard for when they have this authority is very broad. It's whenever there is a release or a substantial threat of a release of a hazardous substance and into the environment, or anytime that there's a release that may present an imminent and substantial danger to the public health and welfare. So the EPA has pretty broad powers. They can go on site and perform on-site sampling. They can send out what are called 104 letters, where they say to a company, we think that you sent waste here, tell us your connection to this contaminated site, to Gus's farm.
It's kind of like prove that you did, which sounds onerous, but it's what you ultimately have to do.
So they're investigating, and there's going to be a cleanup. And I should step back, because we mentioned Section 103 creates an affirmative duty to report spills of hazardous substances, and there are penalties for not doing so. So if you do find your barrels, definitely report. It's the person in charge of the facility is required to report a spill, but it's not all spills. If you spill a teaspoon of solvent in your backyard, or in the back of your facility, I should stop saying backyard, you don't have to report it because there's reportable quantity thresholds. For each substance, there is a limit over which you have to report the spill. For example, acetone, anything under 5,000 pounds of a spill, you don't have to report. So 4,900 pounds of acetone falls in the back of your facility, don't worry about reporting.
Well, check your state regulations.
Yes, check your state regs.
But, yeah, that's right. Always check the state, because the reportable quantity at the state level are always a lot different.
Yeah, and they're generally
They're a lot more strict.
a lot more stringent at the state level.
The idea is that the EPA wants really the only, if you call the National Response Center, which is what they do, they only want to deal with the really big releases.
Not 4,900 pounds of acetone.
Not 49.
There's a sort of similar concept called cleanup standards for when our cleanup gets going. We don't clean up properties to pristine levels. We clean up to a state or federal set threshold of how much contamination we leave in the ground. That's based on both how hazardous the substance is that's in the ground and where the ground is. If you're doing a cleanup in a residential neighborhood, you're going to clean it up close to pristine. If you're cleaning up in the middle of an industrial park, in the middle of the desert, and limits for 1,000 miles, you're going to be able to leave a certain amount of contamination in the ground and still be done with your contamination. For the people on the phone, I just did air quotes around.
You monitor it for a long period of time.
So the cleanup standards are the counterpart to reportable quantities. Yes. So cleanup targets lead us into the cleanup process. 104, Section 104 CERCLA also gives EPA broad powers to either clean up a site, or to allow a PRP to clean up a site, or to issue an order to a PRP to clean up the site. Under the EPA's enforcement first policy, EPA will usually ask or order PRPs to clean up a site before expending their own funds to do so. A copy of that policy is in the reference materials. Generally, like most environmental programs, the states and the EPA cooperate. A lot of times the state takes the lead on a cleanup, and that allows they're more on the ground and they're closer and it's easier generally. There are two types of Superfund cleanups. There's removal actions, which are short-term cleanups designed to respond quickly and to minimize potential damage. And then there's remedial actions, which are the long-term cleanups designed to rehab a site and bring it back into use. In practice, the distinction between the two, where one starts and the other one stops, is kind of gray. And there's different rules for implementing the two. We're not going to get into all those rules because that would be its own presentation. But despite the differences, regardless of what type of cleanup you're doing, it has to conform to the National Contingency Plan. The NCP is a set of rules and procedures for responding to a release. If the EPA or the PRP doing the cleanup does not conform its cleanup to those rules, it will put in danger its ability to recover costs down the line. For sites that are being cleaned up, the worst ones, in the sense that they're the highest priority, go on the national priorities list. The EPA has a whole hazard ranking system that they go through for sites that decide if it goes on the MPL. Just know that if a site's on the MPL, it's worse generally than a site that's not on the MPL. And there are rules about how cleanup costs work for MPL sites, but again, way too far into the weeds for this presentation.
So once the EPA is done with the cleanup, they now get into sort of the risk allocation, the liability allocation component of the story. EPA wants to recover its costs from the PRPs because, historically, that there was the Superfund, which was intended to have the money that contained the funds that would go to cleanup, but the reality is the Superfund is bankrupt. It hasn't had money in it for years because Congress has never reauthorized the chemical tax that was intended to fund the Superfund. So the primary mechanism that EPA uses to fund its cleanups is to go after the money that the PRPs have. So that's why Superfund has its incredibly broad statutory scheme for recovering costs. Michael has been discussing the environmental response portions of the statute. Now we're talking about the compensation and liability portions. The most general way of putting it is that CERCLA provides incredibly broad rights of action for cost recovery whenever the public or a private citizen has incurred costs in order to respond to real property contamination. There are 5 elements to a cost recovery action under CERCLA. They're the following. The first is the question of, has there been a release or a threatened release? And as Michael mentioned at the beginning of the presentation, this is read incredibly broadly to basically mean any kind of leaking, dumping, abandoning, disposing, leaching, escaping, anything involving the movement of hazardous substances into and through the environment is going to be classified as a release. The second question you asked is, has the release involved what the statute deems a hazardous substance? Again, this is read very broadly to include almost everything under the sun that's regulated under environmental laws, including hazardous waste under RCRA. with some very key and important exceptions. The most significant of which is the petroleum exclusion, which includes any kind of petroleum or petroleum byproduct, hydrocarbon fractions that end up being released into the environment. So, good job, petroleum industry.
But there are other laws that they can get at you.
Well, yeah, right. It's not just,
especially at the state level.
Right.
If you want to dump some oil on the ground,
Go right ahead. There will be consequences for that. Municipal solid waste is another big exception to it. This exception is very narrowly drawn and really only applies to small facilities only dealing with small quantities of municipal solid waste. In effect, it never really comes up. And then the other big exception is discharges under what is called a federally permitted release. That's wastewater discharge permits, air emission permits. It's anything as a result of something regulated by the Atomic Energy Agency. That's covered by an entirely separate cleanup program. The third element is the question as to whether or not the release has occurred at a facility. And this is read, again, very broadly. There aren't really any exceptions to this. It's any site, real property, anything, anywhere where hazardous substances have come to be located is going to be termed a facility. Typically, the facility is going to be deemed based on property boundaries. So if you spill waste at a facility, spill waste at a manufacturing site, the facility will be deemed the real property boundaries at that site. And then the fourth question you ask is, does this release of hazardous substances at a facility involve one of our categories of potentially responsible parties? We'll go into a little bit more detail on them earlier, and Michael summarized these, but for our purposes, Gus, the current owner-operator at the farm where the release occurred, he is a liable party. Jesse, the person who arranged for transportation of this material to Gus's farm as the transporter, is liable. The old farmer who owned the facility at the time that Jesse dumped the stuff is going to be considered a former owner-operator that's liable under the statute. And then Walter, as the entity that arranged for disposal of hazardous substances, is going to be the fourth category of liable parties in the statute. And then the fifth and final question you ask is, has this release caused the incurrence of response costs? This is an important concept because response costs are pretty strictly defined under the statute, and it involves expending money consistent with the National Contingency Plan. So when Michael talked about all that cleanup program the EPA goes through, all that stuff is a requirement for recovering money, or something similar to it. You have to have incurred money that's resulted in what the case law now calls a CERCLA quality cleanup in order to get money back from responsible parties. Read together, when you have these elements, the PRPs in question, Gus, Jesse, the old farmer, and Walter are jointly, severally, and strictly liable for their contamination. There's no causation elements here, there's no elements of culpability, and any one of these entities is liable for the entire thing. They're all liable together or individually for the entire scope of response costs. The type of response costs you can get include the necessary cost of response, and again, that's just the money you spend consistent with the National Contingency Plan to create a CERCLA quality cleanup. Damages or injury to destruction to natural resources. There's some wrinkles there really involving who can bring suits for natural resources damages. It's only state agencies and trustees, those with responsibility over natural resources. So private parties, by and large, can't bring claims for natural resource damages. And the final category of damages is the cost of any health assessment carried out pursuant to CERCLA guidelines. So if you have to do a health study to determine how hazardous something is, whether or not it goes on the MPL, for instance, any costs you spend assessing public health effects are part of your damages. So to break down the PRPs a little further, the current or former owners or operators are just what they described in the statute. they're just the people who owned or operated the facility. Operation is the concept that they use to get at lessees and people who contract to operate at a facility. The former owners and operators who owned and operated the site at the time of disposal, this is a little bit more complicated because if you notice from the reading of the statute, it doesn't say owners and operators at the time of the release. It says the owners and operators at the time of disposal. This gets tricky because disposal isn't actually defined under CERCLA. So what courts have done is they rely on RCRA's definition of disposal, and it actually includes similar terms as to how CERCLA defines release. So it's things like spilling, leaking, depositing, injecting, dumping, any kind of placing into or onto the land or water. There are some key defenses for this area of liability, but we'll hold off on that for now. For transporters, it is relatively straightforward. It's those who transport or arrange for transportation of hazardous substances to its ultimate destination. But for the actual transporter itself, the real wrinkle is that the transporter has to have played some role in selecting the destination for these materials. So in this instance, because Jesse selected on his own surreptitiously where the material is supposed to be disposed of, he's caught up in the liability for transport. And then the last one is those who arrange for the disposal of hazardous substances. Recent Supreme Court decisions have clarified that this requires an element of intentionality. You have to have intended for hazardous substance releases or disposal to result from your arrangements in order for liability to hold here. The reason why this is important is because of certain contract manufacturing operations. Historically, were liable under CERCLA for incidental releases and disposal that occurred as a result of their operations. So these people would be subject to liability when they really weren't necessarily, wouldn't ordinarily be considered owners or operators. But because releases resulted from their processes, they would be subject to liability. Supreme Court clarified that to say that there has to be some sort of intentionality. You have to constructively or actually intend for disposal or releases to result from your process in order to be liable as an arranger. So moving on to further, now that Walter, Jesse, and Gus have all been judged liable for cleanup based upon their categories of PRPs, and they've all had to pay considerable amounts of money, they're now going to spend more money on their lawyer and try to recover some of these costs from each other and from some of the other PRPs. Really, this is going to be the people who, the other entities who dumped barrels on Gus's property. So what CERCLA has is a contribution mechanism under the statute that allows people who have already been judged liable or who already are liable parties under the statute to recover the response costs that they have incurred by going after other PRPs. There's a long and convoluted history spanning 30 years of CERCLA's existence as to how this operates, dealing with various judicial and statutory changes. We're not going to go into that history because of time differences, because it doesn't matter now, because the Supreme Court in the last several years has clarified where things stand. Just know that now you have the benefit of practicing in a future glorious time where we all know how contribution works, but we don't have jetpacks yet. So the two mechanisms are Section 107 of the statute and Section 113. And really how it breaks down is that following Supreme Court decisions in 2004 and in 2007, Cooper Industries v. AVL and US v. Atlantic Research Corp., we now know that Section 107 is used for contribution actions by innocent parties, those who are not PRPs under the statute, and those who are PRPs who have been subject to corresponding legal action by EPA or state under CERCLA 107 or 107A. All right? And then Section 113 can be used for contribution actions to recover response when a suing PRP has first been subject to civil action under either Section 106 or 107A. The bottom line distinction is that if you've been sued at the outset by the state, by EPA, or another non-liable private party, or a PRP, who's undertaken voluntary cleanup, you've been sued under Section 107. Section 107 is for parties who have undertaken cleanups on their own, or they are innocent parties or the government. But for Section 113, it means that you've already been judged liable by a court, or you're subject to a settlement agreement, and you're using the contribution provisions under Section 113. There's a very important distinction with liability here, and the reason why it's important is because of this, is that under Section 107A, liability is joint and several. But under Section 113, while liability is still considered strict, it isn't necessarily joint and several, which means that when you're pursuing a Section 113 action, the courts disregard joint and several liability, and they actually look at culpability among the various PRPs to determine who among them is going to pay for their share of the cleanup. And there is a lot of factors that the courts have come up with. They're typically called the Gore factors because when the statute back in 1986, when they created Section 113, then Senator Al Gore had a number of factors that he thought should go into the statute to determine culpability and to determine how response costs are allocated. It didn't actually make it into the statute, but courts oftentimes use those factors by going into legislative history and using them to figure out who among the various PRPs is responsible. Oftentimes it breaks down based upon volumetric calculations. How much waste did you send to this site? And using that to say, since you sent 80% of the waste there, you sent 10%, and you sent 10%, 80% liability, 10%, 10%. It's usually, that's typically most often how it works. The other important provisions under Section 113 to go over, is that Section 113 has settlement protection. So if you're a PRP and you've settled your claims with the United States government or a state in a judicially approved settlement, you're protected from contribution claims going forward. Basically the idea is it's a finality for people. So if you've settled up, you've paid your share under a Section 113 settlement, going forward you don't have to worry about further liability from the states or from EPA. It's intended to encourage early settlement by providing people's incentives to cash out early and get a settlement. Section 113 is also kind of known as the rules of civil procedure for CERCLA. There are statute of limitations provisions, jurisdiction, venue, the basic procedural mechanisms under Section 113 and 107 are there. And so that's how CERCLA litigation works.
So having gone through all this mess of CERCLA litigation, Gus is sad. He could have taken necessary precautions when buying the property. He could have gotten protections from liability. When we talked about defenses, we talked about innocent purchasers. There are three types of property purchasers who can escape CERCLA liability: innocent landowners, bona fide prospective purchasers, and contiguous property owners. In practice, the bona fide prospective purchaser, or BFPP, is the most utilized. And all three generally, they're all in the same universe, and in 2003 the EPA issued what's known as the Common Elements Guidance, which sort of lays out what people need to do to secure the liability protections. It's things like assess the property before you buy it, assist the EPA or allow them on the property for cleanups if necessary, and not to make any contamination worse. So if you know the property that you're buying is contaminated, you do all the other steps, but then you dig up the contaminated soil for laying a foundation and you just dump it over there in the creek that's on your property, you're not going to get your liability protection. The main element for all of this is what's known as the all-appropriate inquiry rule. To secure any of the defenses, a purchaser must, before buying the property, evaluate the property's potential to be contaminated. This is generally done in practice by having a consultant perform a Phase 1 site assessment, and they will let you know what's going on with the property. And the Phase 1, if done properly, will meet the all-appropriate inquiry standards. So if Gus had hired a consultant to do a phase 1, they would have found the barrels, he would have called the EPA, he would have had the BFPP, and he would not have had liability under CERCLA.
The important thing for transactional lawyers, if you get into this field, is that the BFPP only applies in the case of an asset sale. So if you're just buying property or stuff, it applies. But if you're buying a company, you can't use the BFPP defense.
So there's also certain defenses for lenders. Gus obviously financed the purchase of his farm. CERCLA has liability protection for lenders because we want lenders to lend into acquisitions. We don't want them scared of acquiring liability when they either lend and take a security interest like a mortgage in a property, or when they have to foreclose on a property. So CERCLA basically says pre-foreclosure, if you don't participate in the management of the company, especially the environmental decisions, then that lender won't have CERCLA liability. And then post-foreclosure, if they have to foreclose and the property is contaminated, they can avoid liability if they take a few steps. First being that they have to try and dispose of the property as soon as practically possible. They don't have to sell it for $5 the next day, but they need to take steps to sell it. They can't just hold it forever and hope it gets more valuable. And then when they're holding it, they can wind down the business. They can they maintain business activities. They can release the property, and they do need to take measures to assist the EPA in any cleanup that's happening. So that's how lenders feel comfortable about lending to companies and avoiding liability on CERCLA. And that is our presentation.
But now we have questions, and we hope that you guys ask questions because we have plenty of time to go over anything you guys want to talk about. If anything wasn't clear, or if you want to dive into something a little more, feel free to raise those now. And I guess we have questions on email too. So
Yeah, probably coming to as they're submitted.
okay, great.
Yeah, and if you have any questions about practicing or
Right.
how we got into what we do, we'll try and answer them.
Hi, I have a question about the provisions for mixing of solid waste with other wastes. And in some ways it seemed to me like it sounded like, oh, dilution is the solution, pollution, and it might, and since most, you said most generators generate characteristic waste, then most generators can mix their characteristic waste with other waste to make it less hazardous or not have that characteristic anymore. Can you comment on that, whether that does happen or whether it encourages it, or maybe there's something in the statute that prevents that?
I've never come across anyone trying to do that.
Yeah, generally you're not allowed to. For the phone listeners, the question
Oh, sorry.
was, generally under the mixture rule, can a company just dilute a characteristic waste to the point that it's no longer exhibiting the characteristics? Generally for the mixture rule, it's if you have a mixture in the ordinary course of your business, it's not treating a hazardous waste by just, I'll just throw it in 1,000 gallons of water and it won't be a problem anymore.
See what the question that you're posing is that initially the entity or the business, the generator, will have had a solid waste because he will have this stuff. And then if he says to himself, I'm going to game the system and I'm just going to mix it with a bunch of sand and then stuff it into barrels and ship it off, and then if it's no longer hazardous, great, I'm golden. I don't have to deal with it. But no, at that moment when he has a solid waste that's hazardous, he's subject to generator rules. And once he starts mixing it with stuff, he's automatically a TSDF. So he does that. He's not only in violation of generator standards, he's in violation of all the standards he's not complying with under the TSDF rules.
Yeah, so not allowed.
It's not allowed.
Yeah,
There's a way around that.
Great, thank you.
Yep. Anybody else? Anything on email? Oh,
Yes.
we have one more. Yeah.
Hi, so my question is with regard to the reportable minimum quantities and the boundaries of the property boundaries. Are there ways around like potentially like dividing up parcels and like selling it to different owners and then just having like 4,999 gallons of pellets or something in this little parcel and then
So the question is, could you get around the reportable quantity limits by having facility boundaries? And it's not.
The people in the room are very much interested in getting around regulation. So that's cool, you know. I mean, hey, we're into that. You know, we're business lawyers.
A release is a release. I guess maybe I wasn't clear when we talked about it. Like if you have 4,900 pounds of sulfuric acid that is dumped at one point, if it's dumped on your property and onto the neighbor's property, it's still released in the report.
It's not property boundary
for that.
specific for a reportable quantity event. And in practice, you know, the purpose of the reportable quantity designations by and large are to deal with accidental, you know, immediate kind of releases. So like, oh crap, we just dumped this barrel over because our forklift knocked into it. We just knocked over 5,000 pounds of acetone. You know, they're not gonna like, quick, let's subdivide the property to deal with it. You know, it's just that would be in and of itself more costly and difficult than just taking berms and sand and gathering material up and shipping it offsite, reporting it, yeah, and doing it with it. It's just, and again, as Michael mentioned, it doesn't depend on the reportable quantity designations aren't facility specific. And this is the real point.
Anything else?
My question is more about what you guys do.
Yeah, absolutely. Shoot.
So you mentioned at the beginning that most of what you do is like in business transactions rather than remediation and like consulting, I guess. What sort of issues do you deal with?
It's a good question. So the question was basically describe our transactional practice. You know, it's definitely changed over the years. 6 or 7 years ago, we were doing more compliance counseling, but our practice has evolved. So when we're doing a transaction, I've described it to my mother actually because she asked me a similar question. And I said, like, if you were setting someone up on a blind date, and they would ask questions about this person that they have to go to dinner with, you know, are they crazy? It's kind of like where we start. So a company is going to buy another company, and we ask questions about that company. What's your environmental health and safety policy look like? Do you have liability? How many tanks do you have? Are they in compliance? Are you sending waste
discharges do you have to the water, to the air? What are your records for these things? You know, we ask like a whole slew of questions to investigate. So in terms of what issues we confront in these transactions, pretty much everything, because there really isn't a sector that are.
Yeah, we look at companies from all kinds of sectors.
And represent a lot of banks. So pretty much any time that a bank loans money to or invests in a business, we have to look at it.
I also have to investigate the business.
Yeah, so you can really think of it as a three-part process. You identify risk, you quantify the risk, and you apportion the risk. So that diligence part is the identification. We look at the business. And then we quantify it. We say to our client, they have X risks, and it may cost you Y dollars. And then we apportion it. We look at the contracts, and we say, who should be on the hook for these liabilities? Is it going to be the person I'm from, or am I keeping it because they're reducing the purchase price? So that's sort of the three-step process that we go through when doing a transaction.
The third step is a negotiation process of saying who's going to be responsible for what based upon the parties' respective positions. If you're representing a bank, by and large, the people who are working with the bank do whatever the bank says. But if you're, you know, between buyers and sellers, it gets much more sort of nuanced.
Is that a good answer for your question?
Yes.
A mediocre answer, somewhere in between? Cool.
Pretty good.
All right. Well, if you have any follow-up questions, my business cards are up front. You can grab one.
Someone
Shoot